So, hi everyone. I'm Alisha Cahall, and this is Judith Bomster. We're happy to be back at Community Bridges this afternoon to speak with you all about guardianship and the other alternatives to assisting individuals with special needs. The goal is to focus on what a guardianship is, when it is needed, and what the process entails. But we will also talk about other alternative tools that may be utilized to assist the individual in the event guardianship is too restrictive on the person with special needs. In New Hampshire, when you turn 18, you are no longer considered a minor, a person incapable of making their own decisions. Rather, when you turn 18, you have attained the age of majority and are legally an adult, and presumed to have the mental capacity to make your own decisions, even if you are someone with special needs that challenge your decision-making abilities. Today, we're going to touch on a few different options a loved one can take to help an incapacitated adult or an adult with special needs. So in our day-to-day lives, we often take for granted the fact that we have the autonomy and the freedom to make our own personal choices with respect to an array of different areas, from our privacy to where we want to live, to who we want to associate with, our professions, our health, and even how we spend our own money. All adults, even those with special needs, are presumed to have mental capacity to make decisions for themselves, unless that person is considered legally incapacitated and needs a guardian to make decisions for them. Incapacity is a legal term of art, and it's not measured by a medical diagnosis or even disability, but by the functional limitations of the person, that is, the behaviors or conditions which impair the individual's ability to perform minimal activities of daily living that will secure and maintain proper food, clothing, shelter, health care, or safety for themselves. We'll soon discuss this in a bit more detail, but first, we're going to talk about a hypothetical person named Sam.
So before we get to Sam, we did want to let you know that we did print out the slides, and some folks I can see are note takers, like I am. Those slides are going to be available online with our video.
And then you also have them in front of you,
Yeah.
printed 3-2 page.
Yeah, go ahead.
So Sam has just turned 18, and he is still in high school. Sam is now considered an adult by law. He's able to fully manage some of the questions that we now have to ask about Sam is he, now that he is 18, fully able to manage his personal and medical matters? Can he make financial decisions independently? Could he be vulnerable to others, and might friends or strangers or even family members take advantage of him? And might Sam benefit from additional supports, perhaps a parent or another trusted individual to help him with decision making? Now we're going to add a little bit more into the mix. So we said Sam is 18. He is still in high school, and he lives at home with a parent or maybe both parents. He also has some unique needs and disabilities. And now that he's 18, he could apply for Supplemental Security Income, or SSI, a cash assistance program based on financial eligibility criteria, and we kind of discussed that at our last discussion here, which will be on that video that will be coming up if you weren't here last time. So again, it's a cash assistance program, SSI, based on financial eligibility criteria to bring additional cash into the household to provide for his support and maintenance, that is his food and shelter, on a monthly basis. But Sam is not a saver, and he impulsively spends all of his money very quickly on things he wants rather than on the things that he needs. And then Sam is also a very, very generous person. He would give the shirt off of his back to a sibling or a friend or someone else who is in need. Again, Sam is 18. He is legally an adult. He calls the shots, and he is in charge of making all of his own decisions. School officials and Sam's doctors will not speak with or take direction from Sam's parents now that he is an adult. And they won't take direction from Sam's parents without Sam's permission. Sam has to give them permission. Or Sam will either have to advocate and make decisions for himself if he doesn't want to give permission for the school officials or his doctors to speak with his parents. So, Sam is 18, he has to apply for SSI or SSDI on his own, well, SSI on his own. Or he has to apply for Medicaid on his own. So, he can apply for SSI, or he can apply for Medicaid for adults with disabilities, or he can apply for food stamps, and then some other public benefits that he might be eligible for. But the question is Sam eligible for some or all of these benefits due to his disability and earning potential? And similar to school officials and Sam's doctors, government agencies won't process an application for benefits for Sam without his participation, he's 18, or permission for them to speak to someone Sam has designated. Sam is also determined to get his driver's license, but his parents and doctors agree he should not be driving because of the difficulty of multitasking behind the wheel. There are many different and challenging situations that not only Sam, but others like Sam can find themselves in, and each scenario is going to be different. It's unique to that individual because everyone is different. They're not going to be exactly like Sam. As a parent or a loved one, you already may be thinking about what you want and can do to help Sam. As a starting point, some things to consider would be, can Sam understand and execute health or financial powers of attorney documents because he does not need any assistance with decision making now, but he might in the future if he loses capacity? Or can Sam understand and execute a supported decision-making agreement because he does need some assistance with decision-making now? Or is guardianship truly necessary because Sam does not have the mental capacity to understand and make his own decisions now? Guardianship is the most restrictive form of legal intervention there is to protect someone who is unable to make decisions for themselves. It limits the individual's freedom to make independent decisions by appointing someone to make decisions for them. So before considering guardianship, it would be prudent to consider whether there are lesser restrictive alternatives that might fit the situation, such as becoming a representative payee to manage Sam's SSI, or Social Security Disability Insurance, SSDI, those monthly checks, and reporting to the Social Security Administration annually on the use of Sam's money, or holding assets in a joint bank account if a loved one only needs help managing money, or having signature authority on a bank account to help with bill paying and oversight of how the money is used, or lots of other lesser restrictive alternatives available. Yeah. Advanced directives, those power of attorney documents for health care and finances. And if the loved one is still in school, a power of attorney for education as well. Or a supported decision-making agreement if the loved one can make their own decisions independently, but just needs that little additional assistance with coming to those decisions. I'm going to pass it on to Judith.
Yeah, that's a great foundation of where we're going, so it's a good roadmap. I'm going to dive in a little bit and talk about one of the alternatives, which is advanced directives. So this is a foundational document for anyone over the age of 18 who has the requisite capacity to understand the documents, what they do, who they want to step in. And if Sam can, in fact, identify trusted individuals who may be able to handle certain affairs in an order of priority, because we like to stack the deck and not have any gaps, then signing legal documents like advanced directives is a great alternative to guardianship, and it keeps Sam in the driver's seat. Anyone over the age of 18, if they can sign powers of attorney, should sign powers of attorney. It helps families avoid the need to go for guardianship in the court on an emergency basis. And we're focusing on someone who's turning 18, but the same rules that we're going to be talking about for guardianship or advanced directives or supported decision-making agreements apply to someone who's 70 as well. So let's talk a little bit about the legal documents, these advanced directives. So Alisha already mentioned these powers of attorney can come in some different flavors, and we're going to unpack the terms. Financial matters, if someone needs help, health care, and education is what we call a limited power of attorney. So I'm going to talk about all three. These documents are private. There's no court involvement at all. And when someone has the capacity to chart their own course and choose who they want to step in to help them when they need that type of assistance, these are the gold standard. Guardianship is there when someone can't execute advanced directives. They can be fit to tailor and meet the individual where they are and what they want to do and what authority they want to give their agent. So I want to talk a little bit about some terminology so we're all on the same page. Not only do powers of attorney come in the three different flavors, financial, health, and we're going to talk about education, but they also can be limited or general. They can be immediate or springing, and they can be temporary or they can be durable. And I'm going to talk a little bit about each because they really are tailored for the situation and tailored for the individual. So what is an advanced directive? What is a power of attorney? Well, it's a written document. It's designed for an individual who has capacity, the principal, to nominate an agent and successor agents to step in if there's a period of incapacity, and when it comes to financial or education matters, they can step in even if there's not incapacity, if someone needs help and wants another person at the table with them. These documents are revocable at any time as long as somebody has the capacity to understand what they're signing. They can be changed at any time, which is really important for the discussions that we have with an 18-year-old or a 20-year-old who's heading off to college or staying in school after 18, and they say, you know, I want some help, but I don't know that I want my parents to be the person that's nominated forever. Well, this is their opportunity to address the situation. A snapshot in time is how I call it, and it can be modified over time. I also make it really clear to clients that, you know, you're naming someone, they're serving as your fiduciary, they have to act in good faith, and the scope of what they can do, you get to define as a principal. And if they go outside that scope, you can fire them. So someone with capacity gets to decide who can step in, when, and what they can and they can't do. So the agent's authority is strictly controlled by the terms of the document. And we're going to talk a little bit in guardianship. Guardianship, the guardian's authority is defined by the court order. So, and I said anyone over the age of 18. Critically important, but it's really hard sometimes to get an 18-year-old to realize they're not immortal, that nothing's going to happen to them. So getting them at the table, I'm always really proud of the folks who come in early. So I describe powers of attorney as a way to have an additional person at the table. I think I mentioned that. Again, that agent's authority is going to be defined by conversations with a lawyer, or there are some forms that are available online. It's just making sure that the individual that we're working with understands what their options are, understands the authority they can grant, and knows that they can pull back on the authority that they want to give as well. But a general power of attorney is one that affords the principal is cloaking the agent with all authority to handle any matter that might come up, whether it's medical under a healthcare power of attorney or financial. Very broad, kitchen sink style, because you never know what an agent might have to do for you if you lost capacity. A limited power of attorney, like an educational power of attorney, is for a specific purpose, or there are limited powers of attorney that are for a short period of time. So my mother asked me to sell a house that she had in Florida. She was in her 80s. She wasn't traveling down there anymore. She was handling, she was a steel magnolia. She was handling everything on her own. But the paperwork and getting down there and doing all that work, she said, could you do it for me? So we prepared a limited power of attorney for the sole purpose of helping with that sale of the Florida property. She didn't need me to assist with anything else formally. We could just lean on each other. So a power of attorney can be general or it can be limited. Powers of attorney also can be durable or not durable. So a durable power of attorney is one where the principal understands what they're signing, has capacity to give people authority in the document, and it's intended to be used when the person loses capacity in the future. It's a durable, it survives their incapacity. The agent's authority continues on while the principal is still alive. So, if a durable power of attorney also can toggle in and toggle out. So if someone, the example that we had, I think in the slides, is that if an individual has a bipolar condition or schizophrenia, and if that person could be on medication and in therapy and things are going really well and they're handling things on their own, but if they have an episode, the agent can step in and help, can handle those medical matters during that period of time, can handle the financial matters. And then when that individual levels out and things are going well again, the authority reverts directly back to the principal. So they stay in control of when that agent is serving for them or not, if they have the ability to ask for help, or if a doctor's determination says this individual right now can't make medical decisions, we need an agent to come in and help. So they can toggle in and out. So that durability is really critical because incapacity later in life might be temporary, not permanent. Powers of attorney also can be springing or immediate. So we have financial, healthcare, education. We have durable or limited. We have springing or immediate. So all different types of power of attorney features in these advanced directives. So a springing power of attorney says right in the document, the principal who's signing it has the authority to make all of the decisions, and the agent's authority springs into being if that person becomes incapacitated. So a healthcare power of attorney by its very nature is always a springing power of attorney. The principal, the individual, always runs the show on their medical conditions after age 18, unless they don't have the capacity to do so. And if they don't have the capacity to do so, a guardianship might be needed at age 18 forward. Okay? But the agent can never speak for the principal under a healthcare power of attorney unless there's a determination of incapacity. And this is sort of important for families to understand, I think, because sometimes I hear, well, I'm named as my child's healthcare agent, or I'm named as my parents' or my siblings' healthcare agent. And the naming of an individual in the healthcare document doesn't mean you have the authority to make decisions for that person. It means your authority springs into being when a medical professional certifies the person who gave you that authority lacks capacity to make an informed medical choice. So all healthcare powers of attorney are springing. Financial powers of attorney can be springing or immediate. And most of the ones that we do are immediate financial powers of attorney. Even if someone doesn't want another person, their agent, making financial decisions for them independently that day. And the reason we do a lot of immediate powers of attorney is because if an agent ever had to step in and they have a document in hand that says, my child gave me the ability to manage finances immediately, and they have that document in hand, then the agent can act. They don't have to bring medical information wherever they go, proving every time that the individual who gave them that authority lacks capacity to make financial decisions. Immediate powers of attorney are really powerful. If it's a general power of attorney, it's even more powerful. It allows someone to sign contracts for you, open a credit card for you, deal with an insurance company, deal with a salary, open a bank account. I mean, it's an incredibly powerful general document if it's a general, durable financial power of attorney. And if it's immediate, we always say just keep it in a safe place. And if it needs to be released to the agent, then release it. But an agent under an immediate power of attorney doesn't need the document in hand unless they actually have to do something. The healthcare power of attorney can be circulated to everyone named because a healthcare agent cannot make decisions for the principal unless a medical professional says that principal can't make that decision for themselves. Yeah?
So if they have one of those, should they send them like a copy of that to the individual medical provider?
The healthcare power of attorney? Nope, it's great. So our closing letter when we do planning is disseminate the healthcare power of attorney to specialists, to doctors, to hospitals that are closest to you, because an EMT is going to put you in an ambulance and get you. I mean, I have one at Elliott and CMC. I live in Manchester. I have no idea where they're going to take me. It's where they have room. So we always say circulate and give it to the agent. Circulate the healthcare power of attorney so they know the order, they know they're named, but they also need to realize they can't step in and make medical decisions unless that professional says you're incapacitated. You can't make them on your own. Yep.
So for people with Alzheimer's dementia, there's two things that I wanted to ask specifically. When what is that sweet spot between when they become officially incapacitated, they can't sign that power of attorney because they're no longer cognitively able to make that decision. How does an attorney figure that out?
Yeah,
Like, because we did that with my family, it was like, they had to judge if he was.
Yeah.
Right? And the other question is now, a family member has power of attorney for Sam, and Sam fires him. How does that, like, what kind of steps have to happen to firing?
Yeah, that's great. Jump in anytime you
Yep.
want. Okay. Determining capacity to sign powers of attorney is a legal determination. It's not a medical determination. And so what I'm looking for when I'm sitting down with a client is I'm asking open-ended questions. Who might they want to serve instead of, so do you want to name a parent? Do you want to name this individual? Asking those types of open-ended questions. Getting a sense of whether or not the individual understands what they own. Are they earning? Do they have a bank account? Do they understand that taxes might have to be filed? It's really trying to tease out capacity through a series of open-ended questions. I've had some times where I have folks who say, oh, well, come in the morning, because better in the morning, and that's okay. Alzheimer's can have some sunsetting if someone has a particular type of dementia. But I'm not just going to meet with the person in the morning. I'm also going to meet with them at night. I'm going to make this comparison. It is not an easy job as an attorney to determine legal capacity. Mm-hmm. And there are times in my career that I've asked for doctor's letters from a treating physician. It doesn't mean if they say they don't that I can't say that they have legal capacity, because medical incapacity and legal incapacity are different. They rely on the same foundational inputs, but they are a different determination. I've also had times where a guardianship was filed against an individual, and we had them meet with a geropsych individual to get a full assessment, a cognitive assessment, like a MOCA assessment, and we've taken that into consideration. It's difficult, and it's a fine line, I guess. Can I think that? Yeah, please.
Yep. So Judith said medical and legal incapacity are two different things. We could determine that somebody completely lacks the capacity to sign a financial power of attorney, but they could have capacity to sign a healthcare power of attorney.
Good point.
So it's two different standards.
Because it's about making medical decisions about where they live and their well-being versus some higher functioning issues relating to money and contracts and things like that. So capacity can come in different levels as well for different documents. It's a really great point. The second one is, how do you fire someone? Well, if someone's going to fire an individual and an agent, they also have to have sort of legal capacity to do that. And so I've had folks come in and they said, this person is going off-road. They're doing things that are not authorized. We're asking what those things are, assessing if that's a true assessment or not. Did they open a bank account or did they not? And is it a paranoia issue or reality? And then if they do have capacity, we usually have them revoke the document in writing And then we disseminate that document to wherever we think they probably had given it before. And once a third party is on notice, like a bank is on notice, they had a power of attorney on file before and now they have a revocation on file, they need to stop working with the agent at that time. And sometimes a guardianship is needed if the revocation was done without a lawyer and someone just walked in and said, here's my revocation, or I'm firing this person, I tore it up.
So if you do a power of attorney on your own without an attorney, you have to go through an attorney to reverse it?
You don't. You could do something in writing, but I usually do a formal document that says, I signed a power of attorney naming this person on this date, and I'm formally revoking it, and you're on notice. Like, I want to put that third party on notice so that the agent doesn't possibly continue to do bad things if that was the reason for the revocation, right? Yeah, so you don't need a lawyer to sign powers of attorney. There's statutory forms. You know, lawyers can be expensive, and sometimes folks will just, they need the document, and the individual is able to do it on their own. But there's times where it might be helpful to get a little advice, that's all. Yeah. So I think I've gone over some of this already, but we talked about the financial power of attorney. Again, if it's a broad general power of attorney, this is about signing contracts, anything that we do that's financial in nature and that is a personal financial right. So our prior presentation talked about special needs trusts and managing inheritances for individuals. And we do planning that are revocable trusts where people want to avoid probate for family. But the financial agent doesn't manage trust assets. They manage your personal financial rights, the duty to file your taxes, the ability to speak with counselors or education, teachers, or file for financial aid. Those kind of things are part of the financial power of attorney. And it can be as broad or as narrow as you want. And that's why we always have calls with folks, because some folks who are 18 are like, no, I really don't want to include that authority. I want to pare it down a little bit, and that's where the tailoring can come in. So the limited power of attorney, we wanted to highlight the educational power of attorney because, as Alisha said, at age 18, there's this arbitrary and necessary line in the sand that someone's an adult, whether or not they still need some additional assistance or supports or want them, actually. And so the same concept applies. It's a written document. You're naming an agent. You can name successors, and you can decide to give it to someone immediately or hold on to it and say, if I need help with filing next year for my financial aid, then I'm going to give it to you, Mom. So this could allow folks to, as I said, speak with counselors and teachers, access school records, have independent conversations with the school personnel, rather than always having the individual in the room or authorizing the conversations. And that may or may not be what the principal wants to do. They may want to be at every single meeting and don't want to authorize someone to act independently for them. I have other folks who are going off to college and are like, you know what, I really want that assistance. I want someone to be getting the records. I want someone to be talking to the professionals. Yep.
In regards to that, the school should have a copy of that and a signed release too, together to go with their ed file.
Yeah, a signed release is important. So the power of attorney needs to be, it should be recognized by all financial institutions and educational institutions, but then you have folks who we have an internal process that we need to have you sign X. And that's there to supplement. We have had some conversations with legal departments at banks that they want their own particular power of attorney. Someone doesn't have capacity to sign it anymore. They have to accept the one that's there. It was signed, it was executed with all the formalities of the state law, they need to accept it. So if there's a release that can be signed, it's a great idea to sign it. Thank you. So the durable power of attorney for healthcare, it's that companion tool. I've touched on it a bit. Again, a written document where Sam, the principal, is naming an agent to step in, but it is a springing power of attorney. A healthcare agent can't speak for Sam unless Sam can't make an informed decision about medical choices. I want to talk a little bit, before I hand things over to Alisha again, about two other features for healthcare. One is a HIPAA release, the Health Insurance Portability and Accountability Act, HIPAA. I always spell it wrong. I usually put, two P's instead of two A's. But what this does is protect the privacy of confidential medical information. And if the goal is to give someone else immediate access to medical records without the ability to make decisions for you because you have capacity, you could sign a HIPAA release as well at the time. And that would allow the agent to pick up the phone and have conversations and get records. It's just critically important. It's a nice companion piece to the healthcare power of attorney because that agent can't do anything without the authorization of the principal unless that agent doesn't have capacity. So the HIPAA and the healthcare power of attorney have to go hand in hand, in my opinion. And the last thing I want to mention is the surrogacy law in the state of New Hampshire. Many states have it. If someone never signs a power of attorney, and if they're in crisis and there's no guardianship, and someone has to make some immediate medical decisions for them, we have a state law that lists a number of people, family members, starting with family members, in an order of priority. And these folks can step in and make medical decisions in an emergency. But it has a time limit. It's 180 days that folks can make those surrogate medical decisions, after which, if the person doesn't have capacity, the family's going for guardianship. So this is a stopgap measure if someone just had capacity, just never got around to signing powers of attorney, or families never went when a guardianship was needed, and an individual is in crisis. Instead of rushing out for an emergency guardianship, which may be needed in the future, there is the ability for family and folks in an order of priority to make medical decisions. Sure. It is. So that's a great question, but my recollection is it's when the onset of the original disability. So if you have someone who's toggling in and out, I'd need to actually take a look. Mm-hmm. I haven't had a situation where someone had a bipolar condition or schizophrenia. So it may be that it starts another 180 days per spell of illness. That would be wonderful if that were the case, but we'll get back to you on that.
Okay.
Yeah.
Thank you.
Yeah, of course. No, it's good. I always learn something after these. So. Yeah.
Well, a person's in a car accident in a coma,
Mm-hmm.
and they didn't say to their doctor, like I know when I go to my doctors, they ask me, can we speak to your husband, and they ask me who that list is. I'm assuming that's what you're talking
Yeah,
about.
there's a surrogacy list. Yeah.
So what if nobody was on that list?
So it extends out. It actually goes out to family and friends. There's clergy who's on there, and it can go to interested parties. So it's just a way for the individual to approve it. So it's pretty expansive, but it's going to start with parent, and then it goes to children, and it's all children in a class, right? So this is where if you want certain people to make decisions, and when we have this conversation about naming agents, I always say, it's nice to go in order of birth, or is it more important to have someone who's local versus someone who's far away? Our answer is it's important to name the person who's best fit to do that job,
Yeah.
right? Someone can be a pit bull with doctors and just doesn't have the head for money. And so you just need to be really thinking about who you're going to name as agent. But it's a very expansive list of surrogates, but it's going down in an order of priority. Yeah.
Thank you.
Yeah, you're welcome. I'm going to hand it over.
Does it always go to the parent though, so if you have an adult child living independently, not a child anymore, dang it, living independently, they become incapacitated for some reason, and does it automatically shift if they're unattached?
No spouse, no children, it's going to go up to parents.
Okay.
Yep.
There's still a chance then.
But it's 180 days.
Right.
So it is not a solution to planning. Yeah.
How does the, special education, is your little umbrella until you're age 21 or 22, whatever it is? How, I don't remember ever in a special ed meeting after my child was 18, having the school inquire as to whether
It's interesting. Yeah, I've had a lot of clients. I mean, a child can request and
Yeah.
can ask for a parent
Yeah.
to participate or a grandparent to participate. But, after 18, it's the child's decision, and it really, no institution, whether it's education, finances, or medical, should presume that someone wants someone else at the table. They need to just,
Everybody asking,
yeah.
just assume.
Yeah,
Yeah.
yeah.
Okay.
No, we've had some parents who are stopped in their tracks.
Yeah.
We've also had some folks not honor a limited power of attorney for a specific purpose, and we've just had to have those conversations, which is where the release that Jade had mentioned is really important to sign.
We had a situation at one point where there was a special school, meaning that it's a special, not a, it was regular high school. And when kiddos turned 18 who had developmental disabilities, did not have a guardian in play or a power of attorney in play, the school said, do you want to come back in the fall? Do you want it? Nope. Okay, we'll sign you up. If somebody is, if that happens, and the family gets guardianship or power of attorney after, can you retroactively reinstate your child in school? Or is that another, you're gonna have to look that up?
I don't know about the discharge rules from schools, so I don't know the answer to that.
That's a probably special education attorney
Yeah.
you need to
Yeah.
talk to.
So, it happened at Manchester Memorial High School, with my oldest. He left the house every day at noon. I thought he was going to school. Because they were not required to inform me
Mm-hmm.
that they had given him the dropout papers.
Mm-hmm.
It took about 6 months before
Yeah.
I found out.
I mean, they should be able to reinstate, but if you're a guardian, you absolutely should be able to. But I'd probably want something in the court order that specifically authorized me if the parents were coming in with that as a concern. And that way, there'd be, we'd be
That's why-
addressing the issue in
Yeah.
advance at the time the guardianship is obtained. But Alisha is right, she did a fair amount of special education work in the city of New York, so.
Yeah, they bring down their test scores, so they don't want them in there to have that 11th grade test.
Yeah,
Or
so,
they're having
And we should-
behavioral challenges.
should-
that
I'll repeat the
this
questions
school
the
is
next time.
prominent.
okay.
Yeah.
Right, right.
We'll make sure I'll make sure to repeat the questions next time, so it's caught on audio, so I'll do that.
Thank you.
I just realized I hadn't.
No. So it's also, you're thinking about all of these things before somebody turns 18, so that you have these documents in place and are ready at 18 to be able to give them to the financial institutions, to the school officials, wherever you need. I know we're not really thinking about that in our day-to-day lives, but it's something that you, for your loved ones, you want to be thinking about before rather than after they turn 18. Okay? So, supported decision-making. We've mentioned it a few times now, but what exactly is supported decision-making? Or I'm just going to break that down a little bit to say SDM. SDM allows individuals the freedom to make their own decisions on health, finances, and education by allowing them to actively participate and engage in making choices with the assistance of personally selected support networks. The individual needing assistance is called a principal, similar to the power of attorney documents, under an SDM agreement though, and the person assisting the individual to make decisions is called the supporter. The principal can amend or terminate a SDM agreement at any time, so long as the principal has the mental capacity to do so. However, once the SDM agreement is terminated, it is no longer effective. And similar to the power of attorney document, Sam could fire a supporter and then amend that SDM agreement to name a new supporter, so long as he has the capacity to do so. We're always going to be checking on somebody's capacity. A SDM agreement is also no longer effective if the principal loses capacity, so it's important for the individual to also have executed power of attorney documents in addition to a SDM agreement. Remember, the SDM agreement is just allowing personally selected people come in to help that person make decisions because they still have capacity. once they lose capacity, you want to have those power of attorney documents to seamlessly allow agents to step in at that point in time. So they work hand together. Okay, so it's also important to note that it's not indentured servitude. So a supporter can withdraw from the agreement if they are no longer able to serve as a supporter, or if maybe the relationship is starting to get strained and they want to just back out. They can say, I don't want to be your supporter anymore, Sam. Let's think about somebody else you'd want to put in. And Sam can amend the SDM agreement to name a new supporter. The SDM agreement lays the foundation for identifying specific decisions the principal may need help with, and defines the scope of authority granted to the supporter. Medical, financial, and educational decisions are some examples of decisions in a SDM agreement. However, the agreement can encompass a lot of other decisions relating to obtaining food, clothing, and shelter, applying for and managing public benefits or employment, to personal decisions specific to that individual. And then now going back to Sam. If Sam's disability challenges him with reading and understanding financial forms to open a bank account, Sam's supporter may be asked to be an intermediary with the bank and to assist Sam with making an informed decision by explaining and discussing financial information with Sam. So that supporter is in the room with Sam, going through the documents, and at the bank helping him make a decision on whether he wants to open that bank account with that bank. Does that answer the question? Okay, perfect. All right. So a supporter only has a specific authority granted to them in the SDM agreement. Nothing more, nothing outside of the four corners of the SDM agreement. For example now, if Sam does not need assistance with financial decisions, this would be also stated in the SDM agreement. And Sam's supporter could not be Sam's intermediary with the bank in my prior example. So the supporter would not be in the room because the SDM agreement would not have ticked off that he needs help with making financial decisions. A supporter has a duty of loyalty and good faith to the principal, and a supporter must not act in their own self-interest, nor should a supporter exert undue influence over the principal. So as a supporter, you're taking into consideration the individual, what their likes, their dislikes, their beliefs, their moral compass, whatever it is. You're putting yourself in their shoes with everything that you know about them and making that decision based on them, not on yourself. Okay. So we've discussed advanced directives. We've discussed SDM. So let's go back to Sam. The question now becomes, and we've touched on this a few times, does Sam have the capacity to understand and execute power of attorney documents or an SDM agreement? Will he understand and appreciate the role of an agent or supporter, or what the agent or supporter can do if a need arises? Can he fully get his head around all of these things? This is what we're deciphering while we're sitting and we're talking to Sam. Can he understand and appreciate the power of the agent or the power an SDM agreement gives to supporters? And does he wish to impose any limitations on an agent's powers or a supporter's authority? Put those limitations in. Remember, a general POA, power of attorney document, is a powerful document, and an agent can do what Sam can do, make all decisions for Sam for finances or medical, if Sam signs both powers of attorney documents. Whereas with a SDM agreement, Sam is still driving the bus, and he determines what decisions he might need help with. So drilling down, we're talking about someone who is 18. That person is an adult. They're presumed to have mental capacity to make their own decisions, even if that adult has special needs that challenges their decision-making abilities. Determining capacity to sign powers of attorney or a SDM agreement is a legal determination. But attorneys, when we touched on this, we might want a doctor's opinion as well, depending on the individual's disabilities. We want to have that in hand while we're determining whether or not this person lacks that capacity. But only a court can declare an adult lacks capacity and needs a guardian. Attorneys don't do that. You go to court, you go through the court process, and the court will determine whether or not this individual lacks capacity for guardianship, because it's the most restrictive form of intervention.
Can I mention something?
Yeah?
So I wanted to mention, as Jade said, supported decision-making is relatively new. And there is a sample supported decision-making agreement as part of our state statute. And I think Alisha has highlighted, I mean, we're just starting to do these and learning as we go. And the tailoring, just like tailoring a power of attorney, is really critical. And we're going to talk a little bit about tailoring a guardianship order as well. So it's really finding out what that individual needs assistance with and wants assistance with, selecting the supporter for that, and making sure that they're not making decisions for the individual, they're helping the individual make those decisions. And one other thing I wanted to mention, because Alisha was great, she mentioned powers of attorney and supported decision-making go hand in hand. Our state law also says that a guardianship can be tailored in a way to take a supported decision-making agreement into consideration too, to limit some of the restrictions that a guardianship might have on someone. So judges are also being asked to take into consideration whether a supported decision-making can deal with some of these issues so that the guardianship is not quite as restrictive or quite as broad.
Mhm.
Yeah.
Yeah, I've had 2 guardianship hearings where the judge has said to the petitioners, after speaking with the proposed ward, have you considered supported decision-making? I didn't represent the petitioners in that proceeding, and the burden of proof is on the petitioners to prove why a guardianship over a proposed ward is truly needed. And so the judge was asking the questions to the petitioners, have you considered supported decision-making? Has the area agency spoken to you about supported decision-making and has issued continuances for the petitioners then to do some more research on supported decision-making? So I've had 2 hearings now like
So
that.
if you're going and doing those hearings and they're in there on their 18th birthday, but nothing is put into place by then,
Mhm.
what's the time frame for you guys to go back and finish that?
So we're in court and we're waiting on that continuance. It's a timeline up to the judge and when they say the next hearing is, and we're just on the court's timeline for that. Mhm.
And if there was an emergency that was needed, that was medical in nature in that time period, that's where the surrogacy
Surrogacy.
statute can come to the rescue.
Right.
So,
Okay.
yeah.
So.
Sorry to interrupt.
Yeah, no,
Sorry.
thank you. Okay. So up to
Oh.
this,
We have one more.
Yeah.
Sorry, I have a question.
Let's
Do you
repeat.
file the supported decision-making with the courts? And then it's either approved or denied? How does that work?
so the question is, do you file a supported decision-making agreement with the court? So you don't file a supported decision-making agreement with the court. It is similar to a power of attorney document. It's a private document, and that individual, that principal, would have a copy of it, would provide a copy of it to whoever, the financial institutions, wherever he's going or she is going, and that's how that supported decision-making.
But if a
agreement-
judge needs to take it into consideration as part of the guardianship and the scope of the guardianship, then it would be submitted to the court
With the guardian.
so that they could then tailor the guardianship and the authority of the guardian
Should
accordingly.
you have it notarized then?
So,
Then we really don't.
Yeah.
so, yeah.
So, the principal's signature does need to be notarized,
Okay.
but the
Yeah.
supporter signatures on there do not need to be notarized.
So,
I forgot to repeat the question.
helping a family with a power of attorney or paperwork like that, they choose not to go with attorneys. Who is making that decision if the person is, if they have capacity?
Good question.
So the principal is making a decision if they have capacity. And, you know, this is where I think we could add value in helping folks navigate this, but there's no need for a lawyer if someone has the capacity to make selections of who they want the support from and what support they need. And they were designed to be, you know, the form is on this, it's on, part of the statute. They were designed to be utilized by individuals. So it's a hard question to answer. You know, who makes the decision? The principal makes the decision, the person signing and choosing support.
So we're back at, does Sam have the capacity to sign a POA or a SDM agreement? And then when guardianship is needed. So if Sam can't or won't sign the POAs to name agents to handle finances and healthcare decisions when necessary, if Sam can't or won't sign a SDM agreement to name supporters to help him with decision making, if Sam is vulnerable to the influence of others, or if Sam's decisions are likely to place him or others at risk of harm. And then I'm just going to go back a little bit. Remember, we mentioned how determined Sam was to get, or is, to get his driver's license, even though his parents and doctors don't agree that he should be driving. This would be an example of a decision that places Sam or others at risk. So Sam can't or won't sign POAs. Sam can't or won't sign an SDM agreement, is vulnerable to the influence of others, and if his decisions are likely to place him or others at risk of harm, then some form of guardianship might be appropriate for Sam. But only if you've done your research, there are no other lesser restrictive appropriate alternatives that can meet Sam's needs. So guardianship is a legal relationship created by a court. It is a relationship between an individual, the guardian, who is given legal authority by the court to make decisions on behalf of another individual, the ward, because the ward has been deemed by a court to lack sufficient capacity to manage his or her own financial or medical affairs, or make and communicate important life decisions. It's an adversarial process because all adults are presumed to have capacity unless the court determines otherwise. So what does incapacity for guardianship mean? Again, incapacity is a legal, not a medical disability. You can't just go into court and say, my child has autism, I need guardianship. It's measured by functional limitations. That means that the proposed ward or the person over whom guardianship is being sought has suffered, is suffering, or is likely to suffer substantial harm due to an inability to provide for his or her personal needs for food, clothing, shelter, healthcare, or safety, or an inability to manage his or her property or financial affairs. A court is looking at these functional limitations before awarding any guardianship. So if we go back to Sam, the court is looking for specific behaviors or conditions that impair Sam's ability to perform the minimal activities of daily living that secure and maintain proper food, clothing, shelter, healthcare, or safety for himself and others. The person that is asking to be appointed as guardian must prove these functional limitations in court, which may be easy or hard depending on the needs of the ward. An inability to provide for personal needs or to manage property must be proven in court by specific acts or occurrences. They cannot be mere isolated incidents of the person needing help now and then. They also cannot be hypothetical scenarios that could happen but have never occurred. So, for example, the proposed guardian cannot say that they are afraid the proposed ward will leave the stove on or the water running if it has never occurred before. And I can give you another example. I was representing the proposed guardians in another matter, and I had mentioned to the judge that the proposed ward does not know how to eat certain foods. For example, she does not know how to peel and eat a banana, or she will go into the spice cabinet and eat all the spices. So they always keep it under lock and key. And the judge asked me, is that a hypothetical scenario, or has this indeed happened? And it had happened. The judge is listening. They are comprehending everything, and they want to make sure it's not hypothetical. It has happened. There must be a pattern and history. All evidence of inability must be within 6 months before filing for guardianship. 6 months, with at least one incident occurring within 20 days of the filing. Sometimes parents can take really good care of their children, keeping the child safe. It's hard to find an incident. You've protected them so well that you don't have any examples of an incident. So some common things that can stand the test of time are: the proposed ward can't remember to take medication daily. The proposed ward can go to a doctor alone, but won't understand the discussion without a parent present. And the proposed ward can't make change even though they know what money is. They can't make the change. So functional limitations are not isolated instances of simple negligence or a lack of resources and ability to save, or if an act, occurrence, or statement is a product of a misinformed judgment. These are not sufficient proof that someone lacks the ability to provide for his or her personal needs or manage property. Adults are empowered to make poor choices. I'm sure we've all done this. Yes. Unless the actual ability to make an informed decision, to possess the informed judgment skills, is functionally impaired. The guardian standard of proof is high, and it should be, because guardianship is the most restrictive form of legal intervention there is to protect someone who is unable to decide for themselves. And now I'm going to talk a little bit about informed judgment. I touched on it a little bit. But what exactly is informed judgment? Well, it's defined by statute, like the STM agreement, as a choice, and the surrogacy law, as a choice made by a person who has the actual ability to make a choice, who makes it voluntarily after all relevant information necessary to make a decision is provided, and who understands that he or she is free to choose or even refuse any alternative available, and who clearly indicates or expresses the outcome of the choice being made. That's a lot. It entails quite a lot of understanding or alternatives, assimilation of the information, and expression of wishes. This is what we take for granted every day. And now I'm going to pass it on to Judith to talk some more about what the guardianship process entails.
Super. It's a great foundation. So we wanted to talk a little bit about the procedures of this court process. So if someone really needs the assistance in making decisions with healthcare or financial matters and can't exercise that informed judgment, that is, it requires a lot of some executive functioning skills. And they don't have the ability to sign powers of attorney, and they're over the magic line in the sand of 18, then a guardianship likely is necessary. And it entails, as Alisha said, filing a lawsuit in the probate court in the county in which the ward lives. And Alisha also mentioned it's technically an adversarial process because the person who's petitioning is suing the ward to take away some naturally occurring adult rights. The proposed ward, whether they're 18 years old or 89 years old, is going to be appointed an attorney to represent their interests. That attorney is not a guardian ad litem. They are not someone who's coming in to evaluate the circumstances, to look at both sides, and to determine what's in the best interests of the ward. The attorney for the ward is there to advocate for the ward's wishes, even if that ward doesn't truly understand, know, and what it entails. The attorney's job is to advocate for the ward's wishes, not to look at the best interests of the situation. So I wanted to draw a distinction between what Nancy had mentioned.
Who pays for that attorney?
So it's going to be a court-appointed attorney for the ward. But the person bringing the guardianship, the petitioners, have to pay for their own fees if they're bringing the petition, even if it's to protect someone else.
But if the ward has
Money.
the ward is paying.
Yeah.
If the ward doesn't, then the state pays.
So anyone, it's a great, you teed up my next question. So it could be family members can be a petitioner. It could be a trusted friend if there are no family members available. So there's not a limit, but what the court is going to be evaluating is whether or not this individual is going to be able to perform the duties that are needed in a guardianship action to protect the safety and well-being of the ward.
So when you're talking about a petitioner, you're talking about somebody petitioning to become their guardian
Or,
petition to have a public guardian
yes,
for the
yep.
safety of the individual and, okay.
So we're going to, so it's a great question. So who can be the petitioner? Well, I could be a petition and be the petitioner, but want someone else to be appointed as the guardian. And some folks want to be the guardian and some folks don't. They want to be at the table, but they want to preserve the family relationship with the individual. And so there are private guardians who serve. There are nonprofits like the Office of Public Guardian, OPG, and Tri-County CAP. These are organizations that serve the interests of wards as court-appointed guardians. So anyone really can be a petitioner. It's going to be the court who's going to be evaluating whether or not the person being appointed as guardian is the appropriate party to protect the interests of the ward long-term. Alisha had mentioned that guardianships are sort of a restrictive, the most restrictive approach to being able to help someone. And there's a legal presumption that anyone over the age of 18 has the ability to exercise these naturally occurring adult rights. So courts are really cautious on appointing a guardian, and they're overseeing guardians and making sure the ward is protected. And the burden of proof in a petition for guardianship, the person who's seeking either to become guardian or to name a guardian, the burden of proof is the highest possible burden of proof in a court hearing. It's beyond a reasonable doubt. It's what's used for felonies. And it needs to be that high because what's happening is these adult rights are being limited. And everyone has that autonomous right to determine and chart their own course. And if someone else is going to step in and take those rights away, the court has this very high burden of proof for the petitioners. And that's why the specific information that Alisha was outlining, functional limitations, time periods when they occurred, 6 months, last 20 days, not hypotheticals. The court is really interested in that before they exercise their power to take away some rights of an individual. So I wanted to mention also that guardianships come in a couple of different flavors, just like powers of attorney do, but they mirror each other. So there's guardianship over the person, and a guardian over the person gets to decide where the ward is going to live, whether or not they can marry, what kind of medical treatments do they have. It's about the person. And there's guardianship over the estate. That's about money. And that's about how to manage a salary if someone's earning. It's about the ability to sign a contract and whether or not the ward has that ability or can the guardian do that. It can be over both if someone has an estate. Just important to know that if there's federal funds coming into the house in the form of Social Security cash monthly assistance, like supplemental security income, SSI, or Social Security Disability Insurance, SSDI, our courts have a tendency to say there's already a rubric, there's already a way to oversee that. An individual can become a representative payee and report to the Social Security Administration about that federal cash monthly assistance. The court doesn't need to appoint a guardian over the estate because it's already being supervised elsewhere. So we wanted to, I think I already touched on this, but we talked a lot about what the court's role is and what the petitioner's duties are and the burden of proof. But I wanted to just mention again, the ward has rights. And as I said earlier, The role of the lawyer who's appointed for that ward is not to do what that lawyer thinks is in the ward's best interest. It's to do what that ward wants the attorney to do. And sometimes, if an individual, if a ward can't communicate their wishes, then the lawyer for the ward in court would say, I was not able to ascertain whether or not Sam consents and wants a guardian or doesn't want a guardian. And then it's going to be up to the court to decide based on the evidence presented. So if they can't communicate, they can't communicate. If the lawyer can't tease it out, they can't tease it out. But if that ward says no, the job of the lawyer is to contest the guardianship. And so that's sort of a hard pill to swallow if a guardian is needed. But that's the role, and we have a Supreme Court case in New Hampshire kind of tapping the hand of the lawyer who was serving as a guardian ad litem and looking at the whole situation, and it really was in the best interest of the ward, but that was not her job. Yeah. So we did already talk about this as part of these great questions that we had. Who can petition? Anyone who's interested in the well-being of the ward can petition. And the petitioner does not have to be the person who wants to be the guardian. Sometimes folks just want to be involved in someone's care, but it's going to be difficult if there's an institutional guardian. That person who just wants to be involved in the care is not going to be the decision maker. So they have to weigh it very carefully whether or not guardianship is the role they want, or do they just want to preserve the family relationship and have decisions made by someone else. Go ahead,
Would it
Nancy.
be customary or normal or whatever to have an area agency, for example, if somebody's in a staff residence without any family ties really,
Mhm.
or to become guardian, for an agency to petition on behalf of the individual, and then the court appoints maybe a public guardian or something from there?
So I've had hospitals step up and have someone in their custody file a petition to nominate Office of Public Guardian, let's say, to be the guardian. So it's a way of having someone who can see something's going wrong. We've also had cases where someone has had a guardian removed because they might be failing in capacity, as someone asked. And they want to protect the ward's interest, and the court's going to weigh.
Petitioner petitions, not a guardian or remove a guardian, petitioner petitions. They feel that an individual's rights or needs are not being met.
So if there's a guardianship already in place and someone has a concern about whether or not the ward is being well served and whether or not the guardian is acting in the ward's best interest or can act in the ward's best interest, an interested party can petition in that existing guardianship to remove the nominated guardian. But that could be a heavy lift, proof-wise. It could be a heavy lift. So, it's just talking with the clients and really evaluating, is a co-guardian a better option to removal, and then working within the family's dynamic to figure out the best course of action. The powers that a guardian ultimately is going to be granted are determined by a combination of the petition that's filed, the evidence that's presented, and what the court decides based on that. And so the guardianship, the rule is the guardian has to be the least restrictive alternative, and the scope of that guardian and the authority that they have can only be what's needed to protect the ward from harm to themselves or harm to others. So it should be limited. So the order is really designed to afford the greatest amount of autonomy to the individual, not to strip away as many rights as possible, to make it easier for the guardian to do their job. We have some wards who may not be able to drive, but can make a decision on voting. So when families come in and we're talking with them about looking at the petition has a whole lot of rights that a petitioner can check the boxes on. And we don't say select all. Go through it, and what can the ward do? What's the risk? of someone who has a significant physical disability and is not able to, function, do activities of daily living, are we really worried that they're going to get married? And so just really looking at the rights and being selective about what's needed, because the court's going to be looking at those rights. And they'd prefer to see a thoughtful petition filed than one that's just sort of, we want all of the rights taken away from the ward.
And on that, I had a hearing last week. I was representing the proposed ward in that instance, and the petitioners, on the petition for guardianship, as Judith mentioned, there is going to be a page where it has all these boxes for all the rights that you don't think or should, that you're taking away from the ward. And if you have all of them ticked, I can tell you the judge is going to go through them one by one, because she is going to make sure that you thoughtfully thinking about what you're taking away from the ward. Luckily, these petitioners did not have everything checked, and she was very grateful for that. And they had the discussion, and the guardianship was granted because they were thoughtful. They considered the proposed ward and what she could do as opposed to what she couldn't do.
Yeah.
So that was just an example there.
Now it's important to just sort of come at it thoughtfully.
Mhm.
So we wanted to shift off guardianship for a minute and just talk a little bit about documentation that's really helpful to have, either as running up to age 18. If you're planning for the well-being of another, if you're worried about a child who's coming up to 18, if you're watching a family member age, we are, or I am, I say we, be prepared is the motto. Have good documentation, records, educational records, IEP reports, medical records, and keeping those records is critical. I'm big on my spring cleaning, but I really, sometimes more is helpful in terms of documentation. And always bring the interests of Sam into the equation, just at the table, participating in this process. Not everybody who needs a guardian is wholly unable to manage their affairs. And so having conversations about what rights are really important and whether or not they can or can't participate in them, I think is a meaningful discussion. I know I don't have to tell the folks in the room this, but sometimes I'll use an example. My 89-year-old mother lost capacity. We're in a room with the doctor, and I'd step way back and I'm like, talk to my mom. She's the patient. I'll help in any way I can. I might be the final decision maker, but Sam is the patient. My mother is the patient. Have them participating in the process. Yeah, I think I'm good. I think we talked a bit about it.
Okay.
I'm going to pass it over to Alisha. We're going to talk a little bit about a letter of intent.
Yep. So a letter of intent is a document that provides information about the loved one. Sam, in this example, is the disability. You're putting in a letter of intent, what Sam's care needs will be, and it could also include some future care plans that you are also thinking about. It can be a valuable resource for caregivers, others in the support network, or future successor guardians to ensure the person's needs are met. Some examples of what to include in a letter of intent are, I'm going to go back to Sam. You can include Sam's history of diagnoses, hospitalizations, medications, doctors, other professionals, past and present. So this document should be updated regularly. You don't want to leave a letter of intent for somebody who's coming in and Sam's doctors are his doctors from 10 years ago. You might also want to write down some family information and history, the relationships and family medical history. So, when you go to the doctor is always asking you, what's your family medical history? They want to learn more about you, your past, and to where you are now. So somebody else who's coming in fresh and helping Sam doesn't know and has moved him from one doctor to a next, you want to make sure that this information is in that letter of intent. Anything you can think of that you think is relevant should be included in a letter of intent. And this is something you can do on your own. You could just type it up, a Word document, letter of intent. It's like a roadmap for your loved one, for Sam.
We put together a form that can be downloaded from the website for the law firm, just as a resource to give some things to think about. That might be helpful.
Right. Okay. So don't forget to include Sam himself. We said we want Sam as an active participant. So if you'll know his habits, his hobbies, and his routines, you want to include that. You already know everything there is to know about Sam, but the next person beside you who's stepping in won't. So it's, again, all that relevant information that you know that you would want somebody else to know about him, you want to put in a letter of intent. When you're gone, you can't really access that information because, you won't be there for somebody to bounce ideas off of, so you're just leaving this. It's kind of like leaving behind a last will and testament. It's your intent, it's information about him, about Sam, about your loved one. Because only you know the stress relieving techniques, if there is one, certain buzzwords or phrases when he's in or she is in a frustrated state, maybe rubbing of the arms or a word, happy, will help. I also, my guardianship hearing I did last week, the ward does not like the happy birthday song. It gets her really into a state of mind. So it's things like that you want to put in a letter of intent. Keep my loved one from hearing. She does not like the happy birthday song. She will go into a state of anxiety and repression. So things like that you want to put into that letter of intent. Another consideration, so employment history, if your loved one has an employment history, the day programs and activities that they're in, the preferred living situations and their educational limitations and goals. And also, the resources and people and organizations. So you always come to Community Bridges, you see Nancy or you see Jade, put them in that letter of intent. That's a resource for somebody to know that you've been working with these people and they have even more information as well on Sam or your loved one. And of course, government benefits information to maximize medical and financial assistance as well. You know what benefits your loved one is on. Include those award letters as well. Keep them all together because Judith and I, when we meet with our clients, we ask to see those award letters because we're teasing out what benefits he's on. We don't know. You need to provide that information to us. And then for us to give you back the right recommendations and advice, we need to make sure we know exactly what benefits Sam is receiving. And also access to any advanced planning by family members. So Sam's parents, they'll have last wills and testaments, which may name successor guardians for Sam. They both might be the co-guardians now, but what happens if they both when they both pass, or if they both pass in the same event? You're putting your co-guardians that you want to be appointed by the court thereafter. The court they'll still have to go through the court process and be appointed, but it's an intention and a wish that you wanted to name these persons as successor guardians after you've passed on. And the last wills and testaments themselves will also probably direct Sam's inheritance. So does it go to Sam himself or does it go to Sam's Special Needs Trust? People after you need to know what happens with Sam's inheritance and how they can best protect his public benefits in the event it does go out to him. And also maybe information on a life insurance policy that also names either Sam or Sam's Special Needs Trust. So again, you're leaving this information for people to know thereafter, a roadmap for that person. Anything else you want to add there?
No, you made me think of two things. I'm sorry
Okay,
to
yeah.
be distracting.
Yeah.
I'm sorry.
Okay, so we encourage you to read the information that we have in front of you, including the Milestone Ages of Special Needs Planning pamphlet that you've received. That pamphlet is a good resource for learning more about the topics you'll need to consider for a loved one at key age points throughout your loved one's life, beginning with where else but age 18.
I think you just touched on this. You said, like in the last will and testament, if you're naming someone who's going to be a guardian, they're going to have to go through the
process at that time.
Yes.
And how would that happen if you named them?
Yep.
Who would initiate the court?
So they would. So I've named Judith as the successor guardian for my loved one, and I'm passed on. Judith will file a petition to become guardian for my loved one, and she'll include as evidence my last will and testament. But she still has to go through that process, because anyone, again, who's petitioning the court to become a guardian has to be appointed by the court as that person's guardian.
They probably won't have to, again, prove the areas that the person is incapacitated in or whatever. They go through that all over again?
So they don't have to go through it all over again, but the court may want to hear about the ward at that time, right? But the court also has the annual reports that have been filed with the court. So they already have that information. They're still going to have an attorney appointed. So the process is the same because it's a brand-new guardian.
Yep.
And that guardian has to be vetted as well. Yeah, they have to be vetted. Yep, yep, yep. Yeah, there's forms that go along with the guardianship petition that include a criminal background check as well as a background check with the Department of Health and Human Services to see whether or not there have been any complaints against the individual. I'm going to do one thing, and then Nancy has a question. I did want to mention guardianship can be changed over time as well. So just because someone needs a guardian at age 18 doesn't mean they're going to still need a guardian at age 25, or that the scope of the guardianship is the same. And so a ward can revisit things, and that's important, I think, to take away. And a guardianship also can be expanded, and that was what I was thinking. If someone hasn't done advanced planning for, say, an inheritance for someone who lacks the capacity to manage money, and there's only a guardian over the person appointed, but all of a sudden now there's funds, now we'd have to expand the existing guardianship over the person to add guardianship over the estate to it, if there wasn't that kind of advanced planning. So that was what I was jotting down. Nancy, you had a question?
Can you explain to folks, you've gone to court, the judge has granted guardianship. Now you go down to the office downstairs and you sign off on the paperwork. You need to sign a lien. Can you explain the lien and what that is all about for people that don't know that's coming? Have you seen that before?
So are you talking about signing paperwork for a Medicaid lien? I
I've gone
don't know.
to guardianship hearings with families
Mhm.
before, and after the court awards the guardianship, the family goes downstairs to like the
Yeah, it's a Medicaid lien.
registrar's office, and they have to sign a lien. So the lien is if you mess up this guardianship, you
Oh,
become
it's a
an
bond. It's a
unfit
bond.
guardian, right? Is it a lien?
It's not, it's a bond.
A bond.
It's a personal surety bond.
Yeah.
If someone doesn't have a lot of funds, sometimes you have guardians that have to get corporate surety bonds, insurance, so that they don't go down to Foxwoods and go through all the money.
I had somebody that
yeah.
became a co-guardian, and they said, I'm a guardian, and they sent me the document that said, they've agreed to this, guardianship to be added as a co-guardian, but then if you keep reading down, it says, once you do this, and it's a bond that you need to sign. So I'm like, nope, you didn't do that, so that's what it is, thank you.
Yeah, so the question was, what is it? And it's a way for the court to ensure that if that fiduciary, that guardian, acts in a way that harms the ward and causes financial harm in particular, that the person causing that harm has a bond to pay for the damages. And
It's
so,
not the same amount for every person.
no, it's not. No, because every individual doesn't have, if it's a guardianship over the estate, every estate of that ward is different
Right.
from one
Right.
person to another. They might have $10,000 in the bank, that's not Social Security money. Well, they wouldn't get on SSI if they had more than $2,000, but every amount differs. And so if it gets over, are we at 25? To
Four.
go from personal surety to corporate?
25?
25,000.
Mhm.
So anything over 25,000, you're going to need to have an insurance bonding company cover that that person. And I mean, bonds are not super expensive. It could be a couple $100s for, you know, $100,000 or $250,000 bond, but that's every year, right? Because that person is continuing on to manage the money every year. So it's really a way to protect the wards.
So if it's under 25K, they don't need the insurance bond, but
It's a personal.
they still have to pay a fee yearly for the bond?
It's a personal surety at that point. They
Or
just,
one time? Oh, it's just personal.
they
There's no
guarantee
monetary-
it.
It's every year.
Yes, I get it.
Every year.
Thank you.
Yeah, go ahead. Sorry, yeah, sorry,
Who would
yeah.
take over as the rep payee? Does the legal new person, new guardian, like when I die, take over as rep payee, or how does that?
Representative payee also is a process. You had to file with the Social Security Administration to be appointed as the representative payee. So nothing automatically goes to the next person you want it to go to. But a parent's last will and testament, as Alisha mentioned, can nominate guardians of minors. And we include in last will and testaments preferences of a parent for an adult for whom they're serving as guardian now. And courts will take that into consideration as part of a determination of who is going to be appointed as the guardian.
Yeah, so I usually put something or suggest that people put on their calendar. You know, Medicaid redetermination is gonna happen in this
That's a
month.
great idea.
Social Security, we're supposed to do an annual check sometimes and it's phased out. So if you're the rep payee, where did that money go?
And
It's
as-
not complicated, it's just logical. You get $8,000 from Social Security, how much did you charge the rent, that's your money?
Right. And when you're appointed as guardian by the court, you do get in the paperwork that original certification that you're appointed as the guardian, but there are also important due dates that are in there. So when you get that, don't toss it. You might want to write it down on the calendar as soon as you get it. So put it in a safe place.
But that's the end of our formal presentation. So I'm happy to answer other questions. But